Good morning. Our group will talk about contractual remedies in Irish law. We will speak about specific performance, damages, and determination of contract. Specific performance in Ireland. It is made through an order in order to enforce the due performance of the contract. It is a discretionary remedy in equity, therefore the availability of the remedy depends on the circumstances of the specific case. It is mostly used for sale of land contracts, and it is considered the most efficient remedy in protecting the expectation interests of the innocent party to a contract. Usually, if damages are the adequate remedy, then there is no performance needed, and vice versa. Specific performance does not apply in cases of hardship, money advance, and personal services. In countries such as France or the Netherlands, civil law systems, a party can claim specific performance as a remedy in any cases. In fact, in these countries, the emphasis is put on the fact that the promises must be kept and that contracts are seen as moral devices. On the other hand, in countries such as England or Ireland, common law systems, contracts are seen as economic devices, and therefore the court would most likely issue damages instead of specific performance of the contract, since all the system needs is to make up for the economic harm that was made.
Now we'll talk about claim of damages. Damages is another remedy under Irish contract law. It may only be allowed when the loss was effectively caused by a breach of contract. In order to assess for what reasons the damages can be awarded, we'll look at two different tests. The expectation interest allows a claim for recovery of damages for loss of expectation to make a profit and not just wasted expenditure. According to the Robinson v. Hartman case, this test has the aim to place the party in the situation as if the contract had been performed. According to the reliance measure, damages should be awarded for the expenses the party has incurred in preparing to perform the contract, which has been rendered futile by the breach. The second test has the goal to put the claimant in the position he was before the contract was concluded. In the end, the plaintiff should not be able to recover both wasted expenditure, but it may choose either of those two interests. The Hadley and Baxendale case determines the extent to which damages are recoverable. The loss may arise in two cases. According to the first limb, loss is recoverable if it flows naturally from certain breaches of a contract, or, pursuant to the second one, loss is recoverable if it may be reasonably supposed to have been in contemplation of both parties at the time they made the contract. Here, the reasonable contemplation test comes in, where the defendant should be able to reasonably foresee that extraordinary loss would result out of breach. Parallel to the right to receive damages, the plaintiff has the duty to mitigate actual losses. Non-pecuniary losses may be awarded when contract deals with pleasure and relaxation. Avoidance of damages is possible under the frustration doctrine, but the Irish law does not have any legislation on it. In order to avoid going to court, the parties may agree on a fixed sum of money to be paid as compensation to the injured party. There are liquidated damages clauses, which are a genuine pre-estimate of the damage which will probably result from a breach of contract. There are also penalty clauses, designed to deter one party from breaching the contract by imposing a fixed amount to be paid. Under common law, only liquidated clauses are accepted, while the penalty clauses are unenforceable. This is legislation that applies to the claim of damages as a result of a breach of contract. In the civil law jurisdictions, liability in damages may be excluded on the basis of force majeure in France and if the breach is not attributed to the debtor in Germany. German and French law accept both types of damages clauses, but not if the sum is excessive. There is no legislation on the duty to mitigate in civil law. In other matters, the civil law jurisdictions have more or less the same approach as common law.
Now we'll talk about rescission of contract. The rescission is a contractual and equitable remedy aimed at undoing the effects of a transaction. Its purpose is to release the parties from the contract. There are two types of rescission: termination of contract and rescission ab initio on the other hand. Termination of contract. When one party breaches the contract in a way that goes to the roots of the contract, the innocent party is entitled to elect to treat the contract as repudiated by the breaching party. If it so does, the innocent party is relieved of the performance of future contractual obligations. Therefore, the contract is effectively terminated from that point. Rescission ab initio. When, because of some inherent cause of invalidity in the contract, it is treated as voidable ab initio, the contract is valid unless and until rescission is ordered by a court. If rescission is ordered, the contract is retrospectively invalidated. When is it allowed to rescind the contract? There are four cases: mistake, fraudulent misrepresentation, undue influence, and unconscionable bargain. The right of rescission and termination of contract is also present in German contract law and French law. As far as German contract law is concerned, the right of rescission is granted provided that the requirements as laid down in paragraphs 323 and 324 of the Civil Code are met. The right to rescind can be reserved in the contract through a clause, but it can also arise by operation of law. On the other hand, concerning French law, in the event of breach of an obligation by one of the parties, Article 1184 of the Civil Code makes it possible for the other party to claim the cancellation of the contract. When the contract does not provide any clause of cancellation, it is up to the courts to appreciate if the breach has enough importance so that cancellation is immediately decided, or if damages will be enough. Cancellation can also be excluded by a clause of a contract. Thank you for your attention.